ama kutoa mustakabali wa miradi hiyo. Sasa tuzamia hili tukirejelea taarifa yetu ya awali ambapo mbunge wa Kilifi South Ken Chonga pamoja na spika wa bunge la Kilifi Teddy Mwambire wamefikishwa katika mahakama ya Kilifi hii leo. Viongozi hao walikamatwa siku ya Jumatano wakati wa maandamano ya Azimio. Naam, ni taarifa ambayo tutakuwa tunaendelea kuiangazia na kukujuza ni yapi ambayo yamejiri kutokana na hatima ya wabunge hao kutoka kwenye bunge la kaunti ya Kilifi. Kwa sasa tuzamie hili ambapo kwa siku nyingine tena kinara wa Azimio la Umoja wa Kenya Raila Odinga alikosa kujitokeza katika siku ya pili ya maandamano ya Azimio hapo jana. Wandani wake wakisema Odinga yuko salama na kuwa maandamano ya awamu hii yanaongozwa na wananchi. Raila hajajitokeza kwa umma kwa wiki moja sasa, licha ya maandalizi na maandamano kuendelea. Akizungumza bungeni, kiongozi wa wachache Opiyo Wandayi anasema maandamano hayo yamefaulu pakubwa hata bila ya uwepo wa Odinga. Emmanuel To anaarifu.
Kwa siku ya pili mfululizo, kinara wa Azimio la Umoja wa Kenya Raila Odinga alikosa kujitokeza kwenye maandamano ya Azimio, maswali kuhusu aliko yakiendelea kuibuliwa. Kulingana na wandani wa Raila wakiongozwa na kiongozi wa wachache katika bunge la taifa, kiongozi huyo ni mzima wa afya ila walikosa kufichua aliko.
About Baba, as we know, Baba is very safe.
Baba is here.
And is alive and kicking. And when you see us here, you are seeing Baba. Yes.
Na mtazamaji, turejelee taarifa yetu ya awali, tuvuke moja kwa moja hadi kwenye kaunti ya Kilifi tuweze kupata yanayojiri kwenye mahakama ya Kilifi sasa hivi kuhusiana na kesi ya mbunge wa Kilifi South aliyokamatwa siku ya Jumatano na yule spika wa bunge la kaunti hiyo ya Kilifi Ken Chonga ambaye ni mbunge na vile vile Teddy Mwambire ambaye ni spika wa bunge la kaunti hiyo.
In fact, it is not indicated, and you will never know whether they were helping the police officers to ask the crowd. I'm saying that because under Article 49, the words used are clear. It says bond is a right which can only be interfered with if there were compelling reasons not to be released. The wording of Article 39 is not that there would be reasons, but the reasons are to be of a nature that is compelling. That is a reason that is so serious that it forces a court to decide to limit the right of a person despite a constitutional provision. Your Honor, you will have such a reason either visible in the affidavit or the charge itself. And Your Honor, I urge, and it is the truth, that there is no such reason. What we have is a charge under section 78 of the Penal Code, said to be participating in an unlawful assembly. Your Honor, if you were to read the next section, section 79 of the Penal Code, it proceeds to say that that charge and that offense is a misdemeanor. To use the ordinary words that we use, it is a petty offense. It is an offense that when we first came to this town and this court was organized, they would be taken to the municipal court. It is an offense for which a person ought not be detained at all. Lastly, Your Honor, today being a Friday, we've decided to be very short so that everybody goes for prayers after we have given us a ruling. We urge that this is a matter where, as you sit there, you indicate to us the terms, and I want to propose, it's not our job, but I want to propose like this, for like a member of parliament. In fact, just like you, they are referred to as honorable. First accused is a person you can simply come back on Thursday without signing a document, and they will come. I therefore urge that you give very lenient, very reasonable bond terms with an alternative of a cash. That's all.
Your Honor, on behalf of the second accused, first of all, I wish to fully associate myself with the submission of my senior, Mr. Mbunge, especially the authorities that are decided by the prosecutor. Secondly, Your Honor, the second accused, the policy analyst employed by the Parliamentary Service Commission and has been assigned to the office of the Minority Leader, Senator Mazaya, who is present. Your Honor, the accused person is presumed innocent until he is convicted or he pleads guilty. In the present case, the charge for which the second accused is facing is a misdemeanor and is a bailable offense. And therefore, for the prosecution to oppose bail, they ought to give compelling reasons as to why the accused persons should not be released on bail. Your Honor, if you look at the charge sheet, it alleges damage and harm to the members of the public. Look at the particulars, Your Honor, saying that on the 5th of July 2023 at the Papa area in the South County of Kilifi, County of the Republic of Kenya, took part in a procession, maandamano, and chanted anti-government slogans, thereby causing members of the public reasonably fear that they were assembled to commit a breach of peace. You are looking at the witnesses that have been lined up. There is none who is a member of the public. As stated by Mr. Mbunge, 6 of them are police officers, starting with their senior superintendent Leonard Kudat, and the rest up to PC Benjamin Mkiti. So, as the charge sheet stands, there is no member of the public who is a witness in this case and who may have been threatened by the alleged presence of the accused persons at Mpapa on the material gain. Your Honor, it is common ground that demonstrations are allowed by our Constitution. And in this case, if you look at the affidavit, in support for the application to that deny bail, there is no mention of what the second accused person did to deny him bail before this court. The affidavit just makes general and wide allegations. It's like in this courtroom, everybody is here to listen to the proceedings of the court. So we cannot say that they were in court when the offense is committed. If there is a criminal liability, it goes to an individual, not to the crowd or to the number of people that are available at that particular point. So, Your Honor, we oppose the application. The Senator Mazar is present before court. He can sign bond for his assistant to appear before this court at any time, whenever he will be required to appear before this court. When I pray that the application is processed, and as echoed by my life friend Mr. Magolo, the best Friday gift the accused person can get for them to be committed for bail before they go for the arrest. Thank you.
Yes, sir. Let's first just look at the affidavit that has been brought in support of this application. When you look at it, you will notice that they have not specified any particular section or act that they are coming under. It is a requirement, and they should be able to tell the court under which act, so that the court can be able to act on that. So we start with an affidavit that is already defective. But let us go to Article 19. Article 19, Article 3 is quite clear that all fundamental rights belong to an individual and not the state. So the state has no right then to try and limit the fundamental rights of any accused person, because these fundamental rights are to curtail the excesses of the state. And today, what you have is an example of curtailing the rights of the person. But then the court must then look at Article 20 and 21, whereby after recognizing the fundamental rights and that they exist, then the court must start by acting in a way that wants to grant those rights rather than deny them. And this does not only include the court, it includes the police officers and other state officers. Yet, they come to this court and give you such an affidavit. So they come and arrest the third accused person, who is a speaker of the county assembly of Kilifi. They do not respect his rights. They keep him in custody for 3 days, and they come to court and ask you, please deny them bail. Based on what? But they forget that Article 28 must then be observed, that you must treat an accused person or any suspect or any person with the dignity he deserves. Does he deserve any dignity? Yes, he does. He's a speaker. They didn't even need to keep him in custody. All they needed to do was to grant him bond. He would have appeared. He was not going to abscond. He was not going to go anywhere. But because they lack that dignity of trying to respect people's rights, they keep him in custody. But let's look at that defective affidavit in paragraph number 3. You're being told that the suspects here, that's including the third accused person, arrived on foot and assembled unlawfully at Mutwapa petrol station. They were not in a demonstration. They arrived there on foot. Those are the accused persons who arrived on foot. They did not come with the crowd. Then the next paragraph tells you they were joined by other people, about 800. They are not telling you whether they called them or they're the ones who brought them or presented them there. So they want you to act on assumptions. Your Honor, not today, not ever. If they want these people denied bail, they must come with facts. And you are told now the accused person wanted to address, did not address. That is the issue. Wanted to address. So the officer who is telling you here seems to be like a person who is a fortune teller, can tell into the future. Yet these people never said any word, because if they did, those words would be in this affidavit. So again, they want you to assume and imagine like the investigating officer. You are being told that the accused person refused to disperse. Disperse under whose orders? Because they must specifically say that an officer by this number asked them to disperse and they refused. That one is also again not there. So they come with a blanket affidavit that has no specifics, that has no names. Your Honor, as Mr. Magola said, is it also possible that the accused persons came to disperse the people and tell them, please, today is not the right day to do this thing, go home? Is it possible? In the absence of evidence to the contrary, it is possible. So then again, this affidavit weakens as we go. It becomes weak. It has nothing substantial. You're then being told in paragraph number 8 that because there are assemblies and riots in other parts of the country where other people have committed offenses, you are told, please punish these ones who are here in court because the others committed an offense. Are they the carriers of their brothers' crosses? Again, Your Honor, not today. And then you're being told that they have threatened to resume. Threatened to resume must then be proved. You cannot come and tell us they threatened. Threatened using which words, where, to who exactly? How did they convey this message of threat? When you come to a court of law, come with facts, not things that we start imagining. It's even hard to imagine. Did they threaten the members of the public with coming later, or is it to the police officers or to any other person? So you're being told, because of that, deny them bond. They are a threat to national security. They have not been charged with anything to do with that. It is not in the charge sheet. So then, an attempt is made by the prosecutor, Mr. Gitoma, to give him to affidavit. And tells you that this affidavit, please deny the accused persons because of the decisions that were made. Your Honor, I will invite you to look at those affidavits. I mean, those decisions. These were persons in both decisions. Threatened witnesses. Asked them to change their statements. Wrote text to them, made text to them. In this case, do you have any kind of evidence of that nature? Did they threaten anybody? Did they make any text? Did they ask anybody to do anything? Yet, those ones were police officers. Which police officer then, in this case, has been threatened? But if you look at the authorities that we have given this court, in the case of Richard Alden versus the Republic, if you look at the case of Sudi versus the Republic, if you look at the case of Obado versus the Republic, all of them that we have given to the court today, and the prosecution. When you bring up issues of national security, it is something that is so grave and so serious that it is subject to proof. Subject to proof. They give you an affidavit that says there are threats to national security, and they want you today to act on it. Again, by assuming that now fails. And if that fails, then we go back to Article 49, which says that if you have compelling reasons, then bail will be denied. So they are now lacking compelling reasons. It is then automatic that the way to go is to grant bail. And if the court, and I believe that the court should be able to see our argument, what then does the court do? Please, Your Honor, even free bond is acceptable. We will not refuse. Let them come and report. Please give those conditions, but let these people go home, because today the state has failed everyone. Nothing to say.
Yes, Your Honor, I will be very brief, and I wish to associate myself with the submissions of my colleagues before me and urge the court to grant bail favorable in favor of the both accused person, who is a personal assistant to the first accused person. Your Honor, I start by saying that the application before this court in opposition to bail by the prosecution seems to relate only to the first accused person. The affidavit before the court and the submissions by my colleague relate only to the first accused person. Therefore, it follows without saying that the second, third, and the fourth accused persons have no objections against them for being released on bond before this court. But Your Honor, specifically I wish to submit that the application to oppose bail is speculative, fanciful, and made out of conjecture. It is based on pure assumptions, and no material in the affidavit has been placed before you by the prosecution upon which this court can use to deny the accused person's bond. You look at that affidavit. It is a cardinal rule, Your Honor, that throughout the web of our criminal practice, an allegation has to be proved by the prosecution. Allegations related to a denial of bail have to be proved to a prima facie level by the DPP. That has not been done for you, as the affidavit is a 12-paragraph affidavit which has no proof of the allegations which are made there. The only submission, Your Honor, that has come before you is that there is the possibility to interfere with the witnesses. And I agree with my colleagues before me that you look at the witnesses lined up for testimony and ask yourself, nani anawazarusha mawe kwa polisi? It is almost an impossibility. No other member of the public has sworn an affidavit before this court to show that I am likely to be threatened by the accused persons, or their presence in Mtwapa on the material day of the arrest caused any kind of damage by way of tumult or commotion. There is nothing, there is no material. What we are saying is just an affidavit which is full of fabrications and lies. On behalf of my client, the further accused person, Your Honor, I would wish the court to even look at him as a personal assistant to the first accused person. How can he be a threat to the national security? And where is that evidence, if he can be? Your Honor, you'll notice that the fourth accused person, by the nature of his work, must at all times be the first accused person. He can't run away from him. There is no material placed before you to show what he did or what he's likely to do if he's released on court. No material has been placed before. Your Honor, only the question of granting bail, the court is already guided by the regulations and the guidelines. But those guidelines places an onerous burden on the prosecution to show the court why a right guaranteed by the Constitution should be curtailed. Your Honor, if you look at the offense, under the submissions by my friend, even if the offense with which they have been charged with is stillborn, it is stillborn. It was not born, it was inchoate, it was not completed. There was no offense. The accused persons were arrested while walking to meet some people who had gathered somewhere in Mtwapa. There was no action or inaction on their part. So the offense with which they have been charged with was not yet completed. It is stillborn. And the court now is being told, on the basis of a child that has not been born, deny these people the right to wait for the rightful baby. That cannot be. Your Honor, the right to association and the right to demonstrate is a constitutional right. And as my colleague Mr. Ombeta has submitted on Articles 19, 21 to 22, material sufficient has to be brought before you for the court to exercise the discretion to deny bail. Because it is a power to be exercised discretionally. Granting of a bail is in the discretion of the court. And the circumstances have not been given today to show why all the accused persons before you should not be released on board. Your Honor, matters which have happened in other parts of the country are not matters for which this court should take cognizance of, as it is being called to do in the affidavit before this court. Because the charge is a criminal attribute specific to the accused person and not to what has happened in other parts of the country. We have not been told, and there is no evidence by way of photograph placed before you that this is what happened in Mtwapa by their mere presence of the accused person that particular day. It is true, Your Honor, that there might have been some destructive demonstrations as well. But is that attributable to the accused person? And the court can take that as a matter of judicial cognizance in a criminal trial. Your Honor, I submit that this application by the prosecution is ill-motived. It is meant to suppress rights for which, Your Honor, you remember when you were in the law school that it took a lot of life to get this right. My colleague, Mr. Prosecutor, is not alive to the fact that blood and life had to be lost so that we can now enjoy the rights that we are asking in favor of the person. Unless I think he was born the other day. He does not understand what we are talking about. These rights should not be curtailed just whimsically as you proposed. So, sorry, apologies to my friend. What I am saying, Your Honor, is, yes, what I am saying, Your Honor, is that Your Honor, what we are saying is that we have the history of these rights which we are trying to defend before. They never came on a silver plate. They came through blood and loss of life. And this is an attempt to take us to those back ages. One must go, who are there, and we know how much price it was paid for the people to be enjoying these rights today. I apply that my client be released on bail, and the application to deny bail be rejected. Your Honor, we had some authorities. My colleague will take us through them.
You know, briefly, I will not take more than 5 minutes on the authorities that all the four will be relying on. But first, Your Honor, let me put the context of these people who have been arrested. Your Honor, one, all these people are Azimio members. Number two, they, being Azimio members, the reason why they are here is a political question, not a legal or criminal question. There are political matters in the fourth liberation of this country. Fighting for 55 million Kenyans, the four gentlemen. See them from that angle, Your Honor. This matter does not need to come before a judicial process. Politics should be left to politicians, not to be brought before this one. Your Honor, the affidavit sworn here is an affidavit that has always been sworn from the year 2017 to August 2022, when the other political side was